According to federal prosecutors, a Chicago attorney provided more than $1 million for personal expenses involving a woman he was romantically involved with. But spending the money wasn't the tax crime. The problem was what he did with those payments when it came time to file the tax returns.
Now the business looking clean, money coming through. Everybody asking who helped me break through. That tax guru got me thinking bigger now.
I'm Tyrone Taylor, enrolled agent. This is case file 030. The attorney who put $1 million of personal expenses on his tax returns, then scripted the witness. Michael Abramson was a longtime Chicago attorney who lived in Wilmette, Illinois. He also had ownership interests in several businesses, including the Leasing Employment Services Company. And according to federal prosecutors, Abramson had decades of experience dealing with business, financial, and tax matters. Now keep that background in mind, because this case starts with something that by itself is not a tax crime. Abramson was romantically involved with a woman, and according to evidence presented at trial, he provided more than $1 million for personal expenses associated with that relationship. Those expenses included money related to a condominium in Chicago's Gold Coast neighborhood, several luxury automobiles, travel, shopping, and restaurants. Now here's a tax lesson you need to understand in this case. You can spend your personal money however you want. The tax problem starts when a personal expense gets put on a tax return as though it was something else. According to the Department of Justice, the evidence shows Abramson falsely characterized personal payments as commissions or loans for tax purposes, and that distinction matters. Calling something a commission doesn't automatically make it a deductible business commission, and writing loan in your accounting records does not automatically create a legitimate loan. The facts behind the transactions have to support the tax treatment. A real loan generally involves an actual obligation to repay the money. There may be repayment terms and records supporting a genuine debit-creditor relationship. So remember this, the label does not control the tax result. The facts do. And in Abramson's case, prosecutors proved to the jury that these personal expenditures had been falsely characterized. The tax treatment also reached the corporate returns. According to DOJ, Abramson caused corporate income tax returns to be filed for Leasing Employment Services Company that listed fraudulent loans as assets of the corporation. Eventually, Abramson was indicted on federal tax charges in 2018. And this is where the story takes a completely different turn. After Abramson was indicted, the federal court ordered him not to contact witnesses. One of his witnesses was his bookkeeper, and she was important. She had provided bookkeeping and accounting services to Abramson's companies for several years. She knew the books, the transactions, and the accounting treatment. She had also previously testified in court, and Abramson had a copy of that testimony. Weeks before his tax trial was originally scheduled to begin in February of 2024, Abramson gave his bookkeeper a copy of her previous testimony. But according to evidence presented at trial, this wasn't just a transcript for her to review. Abramson had handwritten notes on it. Those notes changed answers, supplemented answers, and otherwise scripted how he wanted her to respond. Now think about where we are now. He was already facing federal tax charges. The judge had ordered him not to contact witnesses. And now prosecutors had evidence that he had handed an important witness a marked up copy of her testimony showing how he wanted her answers changed. But there was one more piece. Abramson knew the bookkeeper was going to meet with law enforcement. According to evidence at the trial, he told her not to bring his notes to that meeting. She brought them anyway, and she turned them over to law enforcement. The investigation involved IRS criminal investigations and the FBI's Chicago office. And while the public releases don't tell us originally what triggered the tax investigation, they do tell us something important about the witness tampering evidence. Investigators had the actual marked up transcript. The bookkeeper turned over the document containing Abramson's handwritten changes. So this wasn't simply two people disagreeing later about what somebody said. There was a physical document. And after that evidence came to light, a federal grand jury returned a superseding indictment in March 2024. It renewed the tax charges and added charges involving witness tampering and violation of the court's no contact order. Abrams' bond was revoked and he was taken into federal custody pending the trial. Later, Abrams went to trial. The jury heard approximately 1 week of evidence. On December 10, 2024, the verdict came back, guilty on all 15 counts. The conviction included tax fraud, witness tampering, and violation of the court order. Then, August 25, 2025, Abrams was sentenced to 30 months of federal prison, 2.5 years. The court also fined him $25,000. Now I want to make one thing clear in this case. The more than $1 million figure represents the total expenditures involved in the case. It does not mean that there was a $1 million tax loss. The DOJ and the IRS criminal investigation sentencing releases reviewed for this case do not specify a precise total tax loss figure or amount. That distinction matters. Here's my That Guru take. First, there's 2 lessons here. First, business owners move money between themselves and their companies all the time. Those transactions can legitimately be loans, compensation, distribution, reimbursements, capital contributions, or business expenses. But you cannot determine the tax treatment simply by choosing the label you want. Writing loans in QuickBooks does not make something a loan. Writing commissions on a check does not automatically make the payment a deductible business expense. The facts have to support the tax treatment. And the second lesson is even simpler. Once a tax matter becomes a criminal case, trying to influence a witness can create an entirely new criminal problem. Abrams began with federal tax charges. He ended up facing additional charges after prosecutors proved he attempted to script his Bookkeeper's testimony. And the document containing his handwritten changes ended up in the hands of law enforcement because the Bookkeeper turned it over. So remember this case the next time somebody says, "It's okay, we'll just call it a loan." The question isn't what you called it. The question is what it actually was. If you enjoy learning how the tax system works through real federal tax cases, follow That Tax Guru. Because understanding what went wrong in someone else's case may help you avoid making the same mistake in your own business. Real tax crimes, real court cases, real lessons, That Tax Guru tax crime file stories.
Now the business looking clean, money coming through. Everybody asking who helped me break through. That tax guru got me thinking bigger now. That tax guru ain't no looking down. Yeah. From the chaos to the confidence.